Hello, we're back, and in this segment we're going to be talking about age discrimination in the workplace. And I have the pleasure of having Jack Rosenberg, who's an attorney here in Atlanta that practices in the areas of labor and employment. And you're also a certified mediator in federal court in matters pertaining, I would imagine, to employment.
Yes, mediation is a great way to resolve a lot of these cases, and I'm a contract mediator with the EOC in 3 regions, and I also do private mediations. It's an alternative to litigation, which has become very popular.
Right. Now, Jack, I want to talk about age discrimination because, quite frankly, you know, the baby boomers already started retiring, so we have an aging workforce here, and I'm sure that is going to be more pervasive, you know, as we in the future years. But tell us about the federal law that protects.
Sure. In 1964, the Civil Rights Act was passed. It covered a lot of areas, but it didn't cover age. And in 1967, Congress passed the ADEA, which is the Age Discrimination in Employment Act, and that prohibits discrimination based on hiring, firing, benefits, and conditions of employment for anyone of the age 40 and over.
40?
40 and
okay.
over.
Okay. And you mentioned something interesting there, you know, that made me think. I mean, age discrimination can happen to anybody. It's not based on race, sex, color. Everybody's going to age at some point in time.
You know, that is why the age discrimination is probably the most pervasive discrimination. Not everyone is a man, not everyone's a woman, not everyone's Hispanic, not everyone's whatever, but we all get older. And everyone, as they get older, potentially is going to be targeted for age discrimination.
Right. And funny, you don't hear enough about it, though. You hear about the race, you know, and all those kind of discriminations, but...
With an aging workforce, we are going to be working longer, and we are going to see more cases of age discrimination. And one of the little quirks is it doesn't apply to people under 40. I get a lot of calls from people in their 30s who will say, I was let go because the boss said I was too young for the job, or I didn't have enough experience, or not protected by the laws.
So you can get fired for being too young, basically?
Essentially, yes.
Okay. Well, who does this law apply to?
It's interesting. It applies to employers with 20 or more employees, and those are part-time, full-time, where it would account to about 20 in total. So you could have, let's say, 40 part-time employees. That would amount to 20 full-time.
Okay.
So it would apply to any employer with 20 or more full-time employees. Interestingly, it applies for hiring and firing.
Promotions?
Promotions, laterals, anything. Now,
okay.
There has to be an adverse employment action. For example, if an employee just feels that they were mistreated, or they were put in a corner, or they weren't treated properly, there actually has to be some sort of material adverse employment action, such as a change of pay, a job action, a bad performance appraisal, being let go. For an applicant, it would be someone who is not hired because of their age. I get a lot of calls from people who say, well, you have too much experience for the job, you're overqualified. And that should be potentially a bellwether or a red flag for applicants for jobs that maybe they're being discriminated against because of their age.
Okay, but can an employer actually not hire somebody because he's overqualified? I mean, that in and of itself is not the problem.
That's correct. There is a part of the law or the case law that is developed. For example, if someone has 10 or 20 years of experience and requires a certain level of salary, then an employer can say, I want to hire someone at a certain salary with only, say, half the year's experience. If it's based on a salary issue or something of that sort, then that is not potentially a violation of the law.
Okay. If a 60-year-old man or woman is let go and replaced with a 45-year-old man or woman who's also protected under this law, would that be discrimination?
You know, that's a great question. That actually went to the Supreme Court. Whether the law required a replacement of someone in the, what we call the non-protected class, that is the ones under 40. or did it apply to a 60 or a 45 in your situation? And the Supreme Court interpreted the law that it was the difference in age. For example, in your case, from 60 to 45 would be 15 years. So let's say someone who is 48 years old is replaced by someone who is 41 years old. That's 7 years difference. And yes, potentially they are covered, the 48-year-old.
Is there a bright rule or line that's saying more than 5 years is discrimination, the difference between them? Or?
Well, since these are federal cases and we have 11 circuits, different circuits have interpreted that anywhere from 4 or 5 years to requiring there to be a 7-year difference. It's never gone to the Supreme Court, and a bright line is a great question as an attorney, and I guess that's why we have so many difference of opinions. But some circuits have said 5 years is enough of a difference, and some say it requires as much as 7 years to be a difference.
How much time does a person have to bring a claim when he has been discriminated because of age?
They're actually, under the ADA, there are 2 methods in which you can break a claim. The first is you can file with the EEOC. You have 180 days to file it with the EEOC. The second way is that you can go straight to federal court. The ADA is one of the few anti-discrimination statutes in which you don't have to pass go or collect $200. You can go straight to federal court, but you have to give the EEOC 30 days notice. So that's an interesting twist on the law. Now, excuse me.
No, go ahead, finish your thought.
Sure. Now, if you wait and file at 181 days, you're out of luck as far as the EEOC is concerned, and you're out of luck totally as being able to make a claim. So if you feel like you've been discriminated against, it's important to get to the EEOC early, and they have various procedures that are very good that can help to resolve.
Okay, and unfortunately we're out of time, but in 10 seconds, what kind of damages can you recover?
Yes, damages, the ADA takes from the FSLA, which allows actual damages, even liquidated, which is ×2. That includes back pay, front pay, and potentially punitive. Okay. Reinstatement is a great part of it, too.
And unfortunately, we're out of time. I want to thank you, Jack, for being with us today. And remember, you can get more information at atlantalatino.com. We'll see you next Sunday at 10 o'clock. Until then, y'all behave. En nuestro próximo programa de Leyes Cotidianas estaremos discutiendo paradas por policía.
Creo que realmente lo único que se le puede decir a la gente es que manejen con su licencia de su país, su pasaporte, que tenga seguro el carro y que traigan incluso su I-94. Toda persona, sea documentada, indocumentada o ciudadana americana, debe ejercer sus derechos en todo momento.
No se pierda Leyes Cotidianas todos los domingos a las 10 de la mañana, aquí en WPBA Canal 30, su canal público de Atlanta.